Hello everyone, this is Muriel Petersheim and I am going to do my presentation on exploring systematic racism before and after the Civil Rights Act of 1964. The fact that systematic racism still prevails throughout our nation is undeniable. Consider the vastly publicized deaths of Black people unjustifiably murdered at the hands of white people, particularly law enforcement, in recent years. George Floyd, 2020, Breonna Taylor, 2020, Philando Castile, 2016, Eric Garner, 2014, Tamir Rice, 2014, Trayvon Martin, 2012. These are just a few of their names. Even though there have been efforts to dismantle systematic racism since the abolition of slavery, too many Black lives have been taken by predominantly white, prejudiced people in positions of power. As a matter of fact, Schwartz and John have confirmed that Black Americans are 3 times more likely to be killed by police than white Americans. Black people have been fighting for their basic liberties, to not be murdered because of the color of their skin, to not be discriminated against for employment or housing, to be able to attend the schools of their choosing, long before these untimely deaths have been publicized. As previously mentioned, while policies have been enacted in efforts to dismantle racism, the focus of this presentation will be on the events leading up to and the enactment of the Civil Rights Act of 1964. Even though the civil rights movement of the 50s and 60s have been deemed the second Reconstruction, we still have a lot of work to do. Despite the duly appointed rights granted by the 13th, 14th, and 15th Amendments of the U.S. Constitution, known as the Reconstruction era, no civil rights acts were actually passed for nearly a century after that, largely due to the legal segregation and continued disenfranchisement that the Jim Crow laws provided. We have all heard stories or have seen media depictions about what life was like for Black people during segregation, which are especially relevant historical cues for those, like myself, who were not alive at the time. With that being said, please allow me to read a small excerpt from distinguished professor of the Pacific McGeorge School of Law, Brian Landsberg article, who was one of the lawyers sent to key southern cities to survey restaurants by Burke Marshall, the head of the Civil Rights Division, when it was clear that the Civil Rights Act of 1964 would soon become law. I had some limited knowledge of race discrimination in public accommodations because I had heard that a privately owned swimming pool in my hometown of Sacramento had turned away an African American girl who had arrived for a birthday party. At this time, however, Alabama totally segregated public accommodations. Pressure from the Kennedy administration had resulted in desegregation of airports, but landing at the recently opened Montgomery, Alabama airport, I noticed that there were 2 men's rooms and 2 ladies' rooms, all in close proximity to one another. Upon inquiry, I found that one set had been built for whites and the other for African Americans, but pressure from the Kennedy administration had led to the removal of the racial designations. For my work in the Civil Rights Division, I walked along the streets of downtown Birmingham, stopped in at every cafe, soda fountain, and restaurant, having a Coca-Cola here, a cup of coffee there, and a visit to the men's room in the next. I took notes on the layout and the menu of each establishment. I noticed that in restaurants, African Americans were served only at the takeout counter. African Americans were sent to a balcony in movie theaters. When I traveled with African American attorneys or secretaries, we stayed in housing on military bases. My colleague Carl Gable recalls using a pay telephone in a bus station in Georgia to call a potential Black witness. When he hung up, a police officer confronted him. "Did you know you were using a colored phone?" The objective of including this excerpt in this presentation is to make us think. These experiences described by Mr. Landsberg depict very real, overt racial discrimination that was not only accepted or tolerated, but legal at the time, which existed less than a century ago. Moreover, these observations came from a white man. Imagine the perspective of this forced reality from the eyes of Black men, women, and children of this time. Even if the Civil Rights Act of 1964 had not passed, surely other measures would have been proposed to overturn these discriminatory policies. The fact of the matter is, though, race discrimination in public accommodations became officially banned under Title II of the Civil Rights Act of 1964. While President John F. Kennedy has been credited for having proposed civil rights legislation, he initially delayed supporting new anti discrimination measures when he began his presidential term in 1961. However, once civil rights movement protests gained momentum and the exorbitant police brutality was used against nonviolent protesters, such as that in Birmingham, Alabama in 1963, Kennedy took action and addressed the nation by stating that the United States will not be fully free until all of its citizens are free. When Kennedy was assassinated in Dallas in November 1963, President Lyndon B. Johnson took up the cause. The Civil Rights Division of the Department of Justice was established in 1957 through the Civil Rights Act of 1957. According to the U.S. Department of Justice, this division's objective is to uphold the civil and constitutional rights of all Americans, particularly some of the most vulnerable members of society. The Civil Rights Act of 1957 also created the Commission on Civil Rights to investigate discriminatory conditions, in which three years later, the Civil Rights Act of 1960 permitted federal courts to appoint voting referees to conduct voter registration following a judicial finding of voting discrimination. Civil rights leader Martin Luther King Jr. said that the Civil Rights Act of 1964 was nothing less than a second emancipation. Because of this act, more rights were given to black voters to minimize the disparities in voter registration, desegregation was set forth, and the Equal Employment Opportunity Commission, or EEOC, was established. A fun fact, Johnson signed the Civil Rights Act of 1964 with at least 75 pens, which he handed out to civil rights leaders such as Martin Luther King Jr., as featured on this slide. According to Dr. Nancy Heitzig, while this legislation made a substantial contribution to effectively dislodging white supremacy from law, the call instead to race neutrality left anti-blackness unchallenged, which is why systematic racism persists. Continued from Dr. Heitzig, more than a century after the Civil War amendments, 60 years since Brown versus Board of Education, 50 years since the Civil Rights Act of 1964, and here we are, with white supremacy and anti-blackness intact. These declarations are evident in the assassination of civil rights leaders Malcolm X and Martin Luther King Jr. following the implementation of this act in 1965 and 1968, respectively. These declarations are evident in the disproportionate rates of black people murdered by law enforcement compared to their white counterparts. These declarations are evident in the data collected by the U.S. Department of Education Office for Civil Rights that verifies how black students are suspended and expelled at a rate 3 times greater than white students, corroborating the reality of the school-to-prison pipeline, since trouble at school can lead to black students' first contact with the criminal justice system. These declarations are evident in the historical and ongoing unequal access to resources, leading to the persistent wealth gaps between black and white households. Thank you.